Hello, everybody. Welcome to our webinar. Thanks for joining us today. My name is Ellen Berge.
Hi, Andrew Bigart here as well.
We're both partners at the Venable law firm in our Washington office, and we've got a webinar for you today on automatic renewal programs, updates and new issues in continuity. We have a lot of ground to cover. Please send in your questions. I'm not sure. We'll try to leave some time for questions, but if we don't have much time for questions, we will certainly try to answer them at the end. We are going to, as I said, cover a lot of ground. We're going to cover with an overview of current legal standards. We've tried to synthesize the standards for you, both taking into account federal and state laws now. We'll talk about some case examples illustrating some of the more pressing and more current law enforcement issues in this space. Talk about some of the newer state laws that have appeared. And since Andrew and I both straddle both our ad law groups and our payments groups here at Venable, we actually have quite a few points to make about payment processing issues in this area. As some of you may know, MasterCard has some fairly recent rules governing continuity and automatic renewal programs that we want to cover with you and just give you a general sense of how payments issues really play into this space. And on that note, I will say we've recently wrapped up our annual Ad Law Symposium, and we hope that many of you were able to join us in April. And coming up on June 6th here in Washington, D.C., we're going to be hosting a Payments Law Symposium. So if you hear some interesting issues today about payments and you want to learn more about payments or you're in the space already, please feel free to join us for that and send us an email, and we can get you the information for that event. So with that, I'll turn it over to Andrew to get started.
Thanks, Ellen. And I guess a good place to start and level set is really understanding some of the basic terminology here. So what are subscription-based offers? What is a negative option? So a negative option program is where the customer's silence or failure to take an affirmative action to reject goods or services or to cancel the agreement is interpreted by the seller as acceptance of the offer. This means negative option marketing broadly is going to include subscription programs, automatic renewal programs, trial offers that are then followed by kind of recurring shipping and billing programs, membership clubs, etc. So if you just think about your own daily life, this would cover things like newspaper and magazine subscriptions, entertainment, DVD or TV programs that you pay for on a recurring basis, coffee of the month club, or maybe if you're lucky, wine of the month club. Dietary supplements and cosmetic programs. These are all negative option type programs, and really there was even an article in the Wall Street Journal recently talking about how subscription programs are expanding into all facets of life. So that's kind of the way to think about it and understand the basic concepts. There's a number of different federal and state laws that govern negative option and subscription programs. We're not going to cover all of them. We're going to focus on some of the key ones here, in particular some of the ones that have had recent developments. So you've got the telemarketing sales rule from the Federal Trade Commission, which basically has various requirements. But for phone, for example, any seller or telemarketer that's offering products or services with a negative option feature have to clearly and conspicuously disclose certain information. The fact that the customer's account is going to be charged, for example, the dates on which the charges will occur, and the specific steps the customer can take to avoid the charges. For online purchases, you've got the Restore Online Shoppers Confidence Act, or ROSCA, as it's normally referred to, which basically establish authorization and disclosure requirements for online transactions with recurring payments. And of course, you've got Section 5 of the FTC Act, which is the main consumer protection authority of the FTC, which prohibits unfair and deceptive marketing practices across all different channels. There are other federal laws that are relevant that we're not necessarily going to cover today, such as the Electronic Fund Transfer Act and Regulation E, which also impact recurring payments. The states have also been very busy in this area recently, and we're certainly going to discuss some of these developments later on in the program. There are automatic renewal laws in California, Virginia, Vermont, and D.C. Some of them are very new. State notification laws for renewal notices. Every state's going to have their own mini FTC Act, which prohibits unfair and deceptive marketing practices, the same as the FTC Act at the federal level. and there's always multi-state coordinated enforcement actions and class action risks that are at play here. So let's dive a little bit deeper into what ROSCA governs. So ROSCA prohibits any person from charging any consumer for goods or services sold in an internet-based transaction through a negative option feature unless the person, 1, provides text that clearly and conspicuously discloses the material terms of the transaction before obtaining the consumer's billing information, 2, obtains a consumer's express informed consent before obtaining the consumer's credit card, debit, bank account, or other payment information for products or services sold through such transaction, and 3, provides a simple mechanism for a consumer to stop recurring charges from being placed on their payment account. So, Ellen, do you want to maybe walk us through how the FTC views a ROSCA violation?
Yeah. So the FTC recently published, this was the beginning of an article that it had written about a particular ROSCA case, and the FTC has many of them, as if you pay attention to their news releases, you'll see. So this is a recipe for a ROSCA violation, but much like you might go online and search for a recipe for chili or something else, there are many, many possible variations of a ROSCA violation. This is just one of them, but it does outline a few key points, and some of these activities, if proven to be true, would be viewed by many as very egregious. And to be clear, it doesn't need to be as egregious as this for somebody to find a ROSCA violation or a violation of California law or other things that we'll talk about. But this does lay out a little bit. It almost gives us an agenda for some points to talk about. So in this particular recipe, you're starting here with a misleading free trial offer, and that is frequently the case. It's been a common marketing practice forever to offer somebody a chance to try something for free. Then the problem is that whenever there's not clear disclosures about what happens at the end of a free trial period. So if you don't cancel, are you getting more product, or are you going to be charged if it's not a physical product being sent to you, but if it's a soft product or software or something like that? Are you going to be charged? Sometimes if it's a physical product, did you have to return it to avoid paying for it? It also becomes an issue. So it does come down to disclosures. Really in step 3 here, an undisclosed program. An undisclosed automatic shipping program becomes the problem. Sometimes marketers will add on additional products to a sale. These are upsells. Sometimes the upsells are also in themselves a continuity program or a subscription-based program. So that requires its whole new set of disclosures and consent, which we'll talk about. And when that isn't done well, and the consumer ends up maybe being in 2 programs that they weren't expecting charges on an ongoing basis for, that's an extra special ingredient, I think, in this one, but certainly an issue. And then illegal charges to credit cards, and this gets into some of the payments issues. The FTC will watch very carefully things like chargebacks, even refund rates. Sometimes, a high return rate or a high refund rate when, frankly, you're not selling shoes or clothing or something that people might buy with the intent to return it. But in certain circumstances, a high return rate can be a problem. High chargebacks, as I mentioned. Difficulty in enabling people to cancel, making it very difficult. We've got a case example coming up here. Remember the 3 prongs of ROSCA Andrew reviewed. That last one is providing a simple, easy-to-use mechanism, and so that this can be an easy ROSCA violation not to. And then number 7, also an extra special ingredient, which hopefully, it doesn't come up too often, but it does come up. Sometimes companies have a hard time finding payment processing services to sell their subscription-based goods and services. And so they will set up a company that is a new company, maybe with listed owners that aren't really doing much with the company, and use that to get a payment processing account. So this was all in this particular recipe. We'll talk about a lot of these topics as we go forward. Okay, so the subscription enrollment life cycle, and this is how we're going to break it down into 4 easy prongs. We're going to talk about disclosures first. What do you have to say? How do you then get consent? Somebody's express informed consent will be the topic there to the offer. Order confirmations, reminding them, letting them know that they've signed up for something, and then, of course, canceling. So with that in mind, we'll go to disclosures first. All right, so disclosures. And again, we, in our past presentations, if you've been part of them, you've seen us sort of break out. We've gone first all the ROSCA requirements, and then all maybe the TSR requirements, and then maybe state requirements. We've tried to boil things down here to give a one-stop sort of clean list of things that are going to be substantially covering all of these different variations. So when you're making disclosures, of course, the key things would be pricing terms. You know, how long are you? How long is the cycle? Is it 30 days? Is it 6 months? Is it annually? And how much is somebody going to be charged at the beginning of each cycle? For trial offers, when does the trial period end? That's really important. And it's not sometimes when does it end as much as when does it begin. There can be a lot of confusion, especially when you're shipping product and you've got an online sale. Does the trial offer start the day somebody completes the order, or does it start the day that they receive the product? And so being very clear about when that happens and paying attention to some of the nuanced legal and other standards on that point can be very important. You know, making sure the consumer understands that this is going to continue, this cycle of shipping and billing or providing a service and billing until they cancel. Again, how much they're going to pay, these recurring charges, the length of the term, if the consumer is required to stay in this program for any minimum amount of time, you need to let them know that. And then, very importantly, how can they get out of it? What is the cancellation policy? It may not be enough just to say you can cancel anytime if you don't tell somebody how to cancel. They are going to need a way to know how to contact you and cancel out of it. Other things to consider when you're making disclosures. In the pricing terms, if there's taxes and fees, you may not know what they are until somebody has frankly put in their address and submitted it, and you can calculate it that way. But some disclosure that some more fees will be charged or taxes will be charged. Sometimes some certain products and services come with additional fees, so it might not just be $19.95 a month, but it might also be then plus an extra fee for whatever it is for that could be tacked on, and so making sure that the consumer understands it's the all-in price. Early termination fees, again, sometimes, depending on what it is, think of maybe even cell phone subscription arrangements. Maybe other subscription arrangements will require you to stay committed to it for a certain amount of time, but if you want to get out of it, you'll pay an early termination fee. So disclosures of that fee, when it will be charged, how much it will be, become very important. And then if you do get out of a program and the company is going to charge the consumer to get back into it with a reactivation fee, a disclosure of that is important as well. All right, how to disclose. So disclosures must be made in a clear and conspicuous manner before obtaining billing information. So a couple of things to break down here. This slide really talks more so about clear and conspicuous. But clear and conspicuous, what does that mean? I mean, in the most general terms, it means easily seen, easily understood, readily noticed, not something that you're going to make your customers scroll down to the bottom of a page to read, something that they'd have to click some link that isn't well labeled to indicate to them that, you know, there's important information here. That's not going to be sufficient. The standards really are now to have disclosures made in close proximity to the offer, in close proximity to where somebody is actually agreeing to the offer. There is some guidance. Actually, a lot of this comes out of the California law, which has written this out clearly, but written disclosures, online or print, this again comes from California law, but in a type larger than the surrounding text or in contrasting type or a font or color. You can do things like put a box around it, make it bold, use symbols, do something to call attention to it. You have to, you know, you want to be well balanced here. You can't you can't be so distracting in certain elements on the page that it's detracting from the disclosure. But you really do want to take a look at this. And for those of you who are counsel for either in-house or outside counsel looking at these offers, you always want to see the screen where the disclosures are appearing. I always ask to see the screens. A lot of times we're just sent the language itself and said, hey, is this language good? And you can read the language, but unless you see where it's appearing on the page, it's not going to do you any good just to look at the language. So if you're over the phone, of course, you've got to have sales reps that are speaking clearly, have a really good script that they're reading to be really clear about the offer is so that the consumer understands. One quick thing before we move on from here. The other thing is before obtaining it, before the consumer's billing information, but making these disclosures, you know, there has been questions and some context about when are you obtaining billing information? Is it at the point that a consumer is typing it into the box, or is it at the point when they're hitting the submit button? So you can think about that. We've you know, I think a lot of us would think that a company obtains the billing information when the submit button is clicked, but there could be some differences of opinion on that. So think about, again, this goes to placement on your screen and how you want to lay out these elements.
Great, and with that, let's move to the next kind of key criteria, which is consent. So the seller needs to obtain the customer's affirmative expressed informed consent. And again, this goes to what Ellen was just talking about, before obtaining the consumer's credit card, debit card, or other payment information. So let's break down kind of what express informed consent means. Express consent means that it must be the affirmative, explicit agreement of the consumer to enroll. Informed consent means having been informed of all those disclosures that Ellen was just describing and talking about, and then providing informed consent based on having received all of that information. And how is that actually carried out in practice? So in an online sale, for example, the regulators, both through kind of enforcement actions and through other forms of guidance, have really expressed the preference for a distinct method by which consumers can affirmatively accept the offer. They prefer a checkbox that has to be affirmatively checked, not something that has been pre-checked, for example, but something that the consumer has to actually go in and click and check. You know, while an I accept or an I agree button can be acceptable, some of this has to do with what's the overall nature of the offer in terms of, you know, are all the disclosures really clear and conspicuous, et cetera? Are you doing a really good job of getting consent? You know, maybe under some circumstances, an I accept or an I agree button can work. But I think what the regulators have basically preferred always is kind of that express checkbox that has to be done. Another important point is that the disclosures, the key disclosures that are being provided about the offer terms, et cetera, and the checkbox providing the consent should not be muddled, you know, with other disclosures, such as, you know, agreement to privacy policy terms, et cetera, et cetera. You want it to be kind of broken off and very clear that what they're consenting to and being able to click that checkbox. Switching to the phone or in-person context, affirmative consent could be viewed as basically requiring the sales representative on the phone to explicitly ask for the consumer's consent to the automatic renewal terms, as opposed to just basically casually asking, is it okay if we move forward, you know, after maybe having provided a description of the offer. I think if you've got, obviously you're going to want scripts for your phone personnel to follow, but I think that having, you know, a very clear obligation to get that consent is critical. And that, you know, we're going to get to talking about some of the newer state laws that have more specific requirements as well. And Washington, D.C., for example, is one of those that has, you know, specific notice and consent requirements for free trials. And we'll talk about that law in a little bit more detail.
So just one quick point before we move on. Back to the disclosures and checkbox should not be muddled with other disclosures. We are starting to see now, and as much as, you know, it's difficult to do and marketers don't like to do it, but we're seeing more of it, is sometimes 2 checkboxes. I've even seen 3 checkboxes now. But what you really have to avoid, and a lot of times, especially on a web page, there's an attempt to get consent for different things. One of them is consent to send text messages under the Telephone Consumer Protection Act, and we all probably, if you're in this space and have looked at that, you know that it's a requirement to make some very specific disclosures about that type of consent, get an affirmative consent like a checkbox thing. But a TCPA consent disclosure really should be separate from a disclosure that and request for consent that you're making for the negative option terms. And even sometimes a separate checkbox for I agree to a privacy policy or your terms and conditions, we've seen that separated out as well. Just because, again, it tends to clutter up the key disclosure that you need to make about negative option. It deals with separate things. So that's something to look at. I think as, again, nobody likes it. It's not appealing. People don't like designing it. It maybe is even confusing sometimes to consumers, but we are seeing multiple checkboxes out there and maybe something to watch for.
Great. So now let's move on to another requirement, which is confirmation. And as Ellen suggested earlier on when we started going through these key terms, a lot of these really cut across the various different either federal or state laws that govern subscription and negative option programs. And so sending a confirmation and an order acknowledgement is really an important factor. So, under ROSCA, for example, there's a requirement to send the purchaser an acknowledgement that has the key sale terms, cancellation policy, et cetera. That's also something California and Virginia require, something that you would send by email, for example, that repeats just the key terms and conditions of what the offer were and the payments that are going to be made as part of that. It's really a best practice across all states wherever you're operating, and the FTC has required this in consent orders with defendants, for example. I think as noted, California and Virginia law require merchants to send an acknowledgement in a way that can be kept, so that could be an email, for example, just with all the key terms. And if the offer is going to include a free gift or trial, the merchant should disclose how to cancel and allow the consumer to cancel before the consumer pays for the free goods or services. And then finally is the cancellation requirement. So under ROSCA, there must be a simple mechanism that the consumer can use to stop the recurring charges from being placed on their payment account. Recent FTC settlement orders, for example, say that if a consumer enrolled online, that particular mechanism should be accessible over the internet or another web-based application. Whereas if they, enrolled over the phone, there should be a phone number or a postal address, for example, that the consumer can follow up on to cancel. And I think, to Ellen's point, one of the ways that these types of cases can bubble up to regulators is where, consumers obviously get very upset and they lodge complaints and they reach out to regulators. And a lot of times that can be driven in large part because they have difficulty canceling what they signed up for, and they find that they're getting recurring payments, after they thought they had taken steps to stop it, or they've reached out to the company, and yet they continue to see their cards being charged. So having a good cancellation, policy and system in place is key, and then actually following through and executing on it so that consumers aren't being charged after they've canceled is really not just a legal requirement, but a great way to kind of minimize potential risk.
Mm-hmm. We're going to get to more of an example of this in a second, but on cancellation, it is that one thing. If there's complaints about an offer, and the FTC looks at all complaints, so they'll look at the ones that they get directly. They'll look at the ones that come in through the states. They'll look at the ones that are going in the BBB. They could go online and read rip-off reports, and state consumer protection regulators will as well. So if there's a lot of noise about a particular offer or a company with a subscription offer, it's not too difficult to go online or even to place a phone call to try to order something, to secret shop the process and hear what disclosures are being made, and see how they appear. But the cancellation piece of it, because it's back end, that's much more difficult. So if there's a lot of complaints, you should really expect a consumer protection regulator to want to probably hear what's on your phone calls, see what you're doing with customer service, how well are you training your agents who are taking these calls, do they have good processes, and are they trained well to sort of make cancellation easy, or are they doing lots of, saving the sale? And can you save the sale? Is that acceptable? And it probably is to a certain extent, but what if you're really sort of doing so much that you're making it really difficult to cancel? So it's some of these cancellation issues can become really tricky, and certainly things to have a really good process for. So again, it's not only these front end, the disclosures and the consent, but the back end side of it with cancellation that becomes important. So.
And so those, were really the FTC standards. There are California standard, for example, that has a little bit more specific requirements, which are that there be a toll-free telephone number, email address, and postal address if the seller directly bills the consumer, or other cost-effective, kind of easy-to-use mechanisms that can be used to cancel. And this mechanism needs to be described in the offer acknowledgement that is sent to the consumer. If a California consumer accepts an automatic renewal offer online, the consumer must be allowed to cancel that offer online, exclusively online. And then California consumers who purchase an automatic renewal offer online are not required to cancel online, but must be given the option to do so and cannot be required to do anything offline, e.g., for example, call customer service or send a letter in order to cancel such an offer.
Right. So all that's boiling down to is you can have multiple mechanisms to cancel, but if somebody has enrolled online, they really must be given that online opportunity, and you've got to tell them how to use it, and you have to tell them that up front as part of the disclosures you're making to them before you get their consent.
Right. So I think now turn it over to Ellen to kind of walk through some actual lessons from law enforcement on some of these issues that we've been talking about.
Yep, and as I mentioned, you can find a new case in this area all the time, and it really does make sense to sort of subscribe to the FTC news releases, pay attention to other things out there, to read the ROSCA cases, pay attention to what California is doing. There's even class action cases in this area, but all this becomes very important for compliance purposes. But what we've been seeing in enforcement recently has really been focusing on marketers who are failing to disclose the terms and conditions adequately under this clear and conspicuous standard. So honestly, I've been doing this for a long time, and I think when I first started doing advertising law, it really was the wild, wild west, and you were lucky if there were any disclosures at all on a page. I mean, oftentimes there were none. And you would find out if you were in a subscription program later. I think we've gotten to a point where now there are disclosures most of the time, but they're hidden or they're buried in terms. They're not meeting the clear and conspicuous standards. So that's an issue now. And then the second focus we'll talk about is failing to adequately disclose how to stop recurring charges, and of course, maybe making it difficult to cancel. So, all right. So, insufficient disclosure. So this is an interesting case, and then I'm going to talk more about the lack of disclosures on the next screen. So bear with us for a second. But here, this is an FTC action against a credit monitoring service. The background here that's important to know, and this makes a point about how you're getting customers into your offer in the first place, lead generation efforts. But here, the defendants were posting fake apartment rental listings on Craigslist, and even, according to the FTC, impersonating landlords in emails to sort of lure consumers into getting a free credit report. And then, when the consumer would go to this website to get the free credit report, to get the apartment that they thought that they were renting, they were actually enrolling in a credit monitoring service. So the FTC's allegations here were that the defendants failed to clearly and conspicuously disclose the material terms of the transaction and failed to obtain express informed consent. Again, here the problems were that the consumers really, they were going here expecting to get a free credit report so that they could move forward with their apartment rental thing, and that's not what happened. So this was the desktop site that's on this screen, and there are disclosures here actually, and they're hard to see, but just because we've shrunk it. But there's some disclosures sort of on this early page at the top about a 7-day trial for this, monthly membership charges, a phone number to cancel, and maybe this would have been okay if consumers had not come into this not expecting that this was how this was actually going down. So I think, again, if you mislead consumers into your offer to begin with, they can easily gloss over these important disclosures. But I think the bigger issue in this case was on the mobile sign-up screen. And I think this is where, if I remember the complaint correctly, most of the sign-ups for this were on a mobile screen, like 90% or something like that. And here, this is imagine if this is A and B were sort of one long scrolling page on your iPhone, but this is what it looked like. And again, I apologize, it's hard to see because we shrunk it, but all of those disclosures that were on that desktop screen that we just looked at are not here. There's really no disclosures here. And so this was, as the FTC had put it, really the issue and really what constituted the ROSCA violation. And as you can read, nowhere on this page does it disclose that consumers attempting to obtain their free credit report and score in order to tour the property they wanted to rent will be enrolled in an unrelated credit monitoring program and charged $29.94 a month. So this was the issue there. There was a judgment against these defendants in the Northern District of Illinois that they are appealing. I think they're challenging some other issues in this case, but this case is still ongoing. Okay, so the next issue, Adore Me is a online retailer of clothing, and their business model was to charge a customer about $40 a month. This entitled the customer to credits that they could use on the site to buy apparel and clothing. The issues here went to the inadequate cancellation mechanism prong of ROSCA, and the FTC alleged that the defendants here created a barrier to cancellation by repeatedly declining to accept, process, or act on cancellation requests made by consumers through one means, such as the phone, and directing them to go cancel online. So consumers were kind of getting the runaround. They'd wait on hold for, as the FTC had alleged, 11 to 32 minutes sometimes, average wait times. That seems like a really long time. But that, after waiting, imagine after waiting for 32 minutes, you reach somebody who tells you just to go online to cancel and tells you a website to go to. And then as the FTC described it, you were then faced with a long and drawn-out cancellation process online. You had to take a quiz, answer questions, go through multiple web pages, and then so that was some of the difficulty. And then other FTC allegations made it really hard, or didn't even accept cancellations if the customers already had an order in transit, wouldn't take it at that time, made them call back, or if they did allow some customers to cancel, if the customers had built up store credit with all of the monthly fees that they had been paying, the retailer said they were not going to refund that store credit. So not having disclosed that up front as part of the cancellation policy here became an issue in this case, and, things to keep in mind. We do have a couple slides here just quickly on the DirecTV case. This one was really closely watched because it's, obviously a major brand company. Services like this are clearly subscription-based. We all pay sort of monthly fees for our cable and internet and things like that. But this was a case where the FTC did challenge DirecTV's advertising. I apologize again that this ad has shrunk so badly, but I think with 40,000 different ads out in the marketplace by DirecTV between, almost a 10-year period, we probably have all seen these ads. But the allegations really there were, as you might expect, I can get to them, that, things like a mandatory 2-year agreement period, or you're going to pay an early termination fee for the service. The FTC didn't think that was adequately disclosed, or the fact that after, a lot of these offers were teed up as, you pay this much for a certain amount of time and then your price increases to another amount, that higher price for certain programming packages the FTC thought was not adequately disclosed. The fact that somebody was, or a customer would be receive significantly higher charges perhaps at the end of some trial period. In this case, it was 3 months. That was a problem, according to the FTC. And then, how much just generally the cost of these services. And, that credit and debit card information could be used to charge this information. Now, this case had an interesting outcome because, again, there were maybe as many as 40,000 ads at issue, or, that DirecTV had put out. As I remember reading it, there was one ad that really became the focus of this case, and one ad that the FTC put an expert on and sort of said, it's not, this and that is not clearly disclosed. But the court looked at the ad and, issued an opinion saying, well, we've looked at the ad. We've done a facial review of this exhibit, and again, with apologies that it's small, but we think, the net impression that a reasonable consumer would take away is that, things are disclosed. The promotional price only lasts for 12 months. You have to sign up for 24 months. There's an early cancellation fee of $20 per month if you cancel, other things. And a lot of that came, with what was disclosed in the ad. There's a lot of fine print at the ad as well. I mean, if you, again, you could maybe see it a little bit more clearly on another screen. Sorry, I backed up too, but no better there. But you can see there's a lot of fine print. So it's facially there. This is how this came out. The FTC determined not to pursue this case any further, even though perhaps they could have. But, interesting points to keep in mind, though, about the types of issues that can really cause an inquiry or some scrutiny from a regulator. Okay. So state law enforcement. There's also quite a bit going on in the states. We're going to go through some of these cases a little bit more quickly, but a lot of these emerge in California. California has an automatic renewal law that has been really the prevailing state law for quite a few years now. It's almost like a national standard. It is aligned in a lot of ways with the ROSCA law, but there's more detail to the California law, as we've suggested earlier in this presentation. So there is a task force in California made up of local district attorneys' offices and some state attorneys generals that are pursuing cases in this area. It is a moneymaker for the state. So again, this is an area where you'll see lots of cases, but it's the same, very similar types of allegations. Here's a case against Dropbox, an automatic renewal offer terms that were allegedly not presented in the clear and conspicuous manner, failing to disclose certain key elements about this service. This resulted in a settlement. As settlements usually go, there's some injunctive relief requiring future compliance and then usually a monetary payment. Class action lawsuits have also emerged. There's been quite a few. We see them in California a lot. We do see the class action plaintiffs bar pulling in causes of action under either the automatic renewal statute, or if that does not provide a private cause of action, looking for other ways in, like a general consumer protection law. So class action lawsuits can be extremely painful from a financial perspective and take a long time to deal with, and they certainly do occur in this space. And then just a quick, going through a very quick few states here. D.C. has, I think, the newest law that we've seen, effective March 26th, although there's some question about whether resources or funding has been assigned yet to actually enforce the law, but it is effective. It does require clear and conspicuous disclosure of terms and conditions. There is some unique, there's a unique thing in here that if the term is more than 12 months, and then you renew it for a term of 1 month or more, you actually must send written notice to the customers at the end of that year, and remind them that their agreement is going to renew, they're going to be charged, they have to cancel by a certain date to avoid being charged. And while that is in this new DC law, it is actually also in a few other state laws. So you do need to pay attention to the state laws that have been around for a while. And so some of the state laws will require cancellation if the term, or I'm sorry, notice if the term is, not just your 30-day like clockwork coming to you, but if it's 6 months or more, if it's an annual renewal, some notice there is often required, especially depending on the type of business you're in. The other unique thing about DC is that if the free trial period is for a trial term of 30 days or more, and then, of course, it converts to a paid subscription, you then need to send notice to the customer before the end of the trial period and have the customer opt back in or provide their affirmative consent to the automatic renewal before you start charging them again. So, and you have to do this even if you got their consent up front. So this is a unique thing in DC law that we've not seen yet. Vermont law, I'm not sure, it's here, and, I think you all get the slides, but there's not many sort of new developments here, but you can read the Vermont law. It's a lot of, the same, making the disclosures. There is this requirement, though, to make the disclosures in boldface type. So some things here to pay attention to for your Vermont customers. Virginia law. The Virginia law that has come out is very similar to the California law. So if you are following California law, then you should be all set in Virginia. But there is a specific private right of action under Virginia law for private plaintiffs. So that's an important note. And then one last quick point on the states is, as we mentioned earlier, even without an automatic renewal law, states have their mini FTC Act. They can simply allege that a practice is unfair or deceptive. They join together frequently in multi-state actions. Here's a couple of examples here. We won't go into too much detail in the interest of time, but multi-state issues in this area can be painful to deal with and result in big penalties, and don't, again, need an automatic renewal law to go under. They can just go under an unfair and deceptive theory. All right, so with that, I'm going to turn it back to Andrew, I believe, to sort of talk about our payment processing considerations in this space.
Yeah, thanks, Ellen. And this is important, I think, both if you're a merchant that is in this industry, understanding what types of pressure and considerations your processor has, but also important then if you're the processor, understanding some of the risks involved with these types of products and services. So if you think of high-risk merchant categories, I think that at least from the FTC perspective and probably from most merchant acquirer perspectives, goods or services with negative option features, trial offers and subscriptions are going to be viewed as high-risk categories, and that will have certain ramifications. For example, there is a specific merchant category code 5968 for direct marketing continuity subscription merchants, and once you're recognized as being that type of a merchant, it's likely that they're going to be subject to deeper underwriting, more kind of robust monitoring on an ongoing basis. And there's a couple different reasons why that's the case. One, if you're the processor or the acquiring bank, if you view these as higher credit risk, you're going to want to protect against that by doing a deeper dive and monitoring better to protect the acquirer. And then there's been pressure from regulators like the Federal Trade Commission that have, under certain circumstances, brought enforcement actions against processors or independent sales organizations, for example, with respect to providing processing to high-risk merchants and then either facilitating their unlawful conduct or really turning a blind eye to fraudulent activity that's occurring. So because of that, you could expect on the processing side for there to be, a deeper look at potential financial risk, reputational risk, review of marketing materials and websites and the like. There's just going to be stricter all-around kind of underwriting of the merchant. There could be processing volume limitations that are imposed and limits There could be much closer scrutiny for chargebacks or refunds. A processor may even ask for an opinion letter or a memo from legal counsel explaining why the merchant's products or services comply with the various different laws that we've been talking about.
Mm-hmm. And the other thing to be aware of, too, is that a lot of processors and banks in this space will ask for reserve funds to be set aside. So that's a financial issue to consider because the chargebacks are higher, refunds are higher, and if the way the payment system works is that ultimately the acquiring bank, which is the bank that is sort of sponsoring your transactions into the credit card system, are on the hook for chargebacks that consumers call in. So, and a chargeback, I'm sure you all know, but a chargeback is whenever you essentially call your credit card, the company that issued your credit card, and you dispute the charge. So the acquiring banks push that financial obligation down to the processors, who push it down to the merchant. But if the merchant is not around, if the merchant goes out of business, or the merchant doesn't have the money to cover the chargebacks, then the banks and the processors do. So higher reserves are also an issue.
So because of this kind of increased scrutiny on this industry from the processing point of view, there's been a lot of different practices that some merchants have sought to engage in order to be able to get broader access to processing. And the Federal Trade Commission in particular has been really focused on these types of activities, both because of going after basically the merchants for doing it, but also if you've got a processor or ISO that's facilitating or assisting in these types of activities, they could be subject to enforcement. So it's things like credit card laundering, which is basically processing a transaction through somebody else's merchant account. The use of shell companies and straw owners. So basically trying to get, basically setting up a new business with just a nominee owner who's not really involved so that your company can process through that new company's merchant processing account. Those are the type of things that might be done because of processing limits even that are imposed on a particular merchant. They want to sell more volume, but they're being limited, so they look to set up more companies that can do it. The opening up multiple MIDs and then being able to load balance by sending transactions between the different accounts. That's something that's often used to try to manage or disguise high chargebacks, for example, by being able to shift volume to different accounts. And then finally, setting up dummy websites, which is really a way to try to get past a processor underwriting by showing a particular website that maybe meets all of the legal requirements, but that's not actually the website that's live, that's being used by customers that are buying products and services.
So this is a web screen here. It's actually taken out of an FTC complaint. It's labeled dummy checkout page because this is the web page that was submitted by a company trying to get a processing account for skincare products sold on a recurring basis. And in the FTC's complaint, it looked at this web page, and actually what's interesting, based on how the complaint is written, it seems like this page is actually done pretty well. So some of the key features here is right on the right side under the final step, there's credit card information. There's a checkbox there with a yes button, and within that language, an indication that there's a $97.81 charge per month. It's an auto ship program. It's going to start after a 15-day trial, which is really 11 days plus 4 days for shipping. Call anytime to cancel. I'm not so sure I would use this as gospel, but this, for now, might have passed muster with a processor as having everything on the screen. But the actual web page that was used is this one. So on this page, as you can see, there's really no disclosures. You probably cannot read the really light gray font at the very bottom, but that's disclosure says initially just pay $4.95 for shipping and handling today to fully evaluate the product for 14 days. We know you'll love it, and you'll receive your product within 5 business days. So that's all that says, and it doesn't say anything about we're going to keep sending you more if you don't cancel. If you don't love it, you have to call us and tell us you don't love it so we can stop sending it to you. And so this was actually the page that transactions were sent through. So it's an example, and processors are constantly looking for ways. They have various tools that they'll try to use to help find these types of dummy websites and vet them out. But they're often the victim of these schemes, and this was from the F9 advertising case. So here you can see in the FTC's complaint, the defendant here lied to payment processors and used other individuals as the owners of the companies that he had been setting up. And by taking these approaches, he shielded himself from consumer complaints and chargeback disputes. He evaded detection from consumers and financial institutions and law enforcement. So clearly, again, in thinking back to that recipe, these are really like hyperactive ingredients that nobody wants to do, but, things to be aware of, especially for those of you joining that are on the payment processing side.
And just one other point on this, too, is that, the card brands have lists that they maintain, for example, of merchants or individuals that have been terminated because of fraudulent concerns and other activity like that. And so what you oftentimes see in some of these cases is an individual that's been put on the match list, for example, trying to set up these separate companies with different quote-unquote owners in it as a way to get around being listed on those kind of prohibited lists. So that's another reason how that pops up.
Okay, so what does law enforcement look for? We've covered this, but again, sort of in trying to get a merchant processing account, making false statements about what you're doing or who you are, failing to disclose material information about your business, who's running the business, for example, who's the manager, who's the director, especially any connection between somebody who you list as the owner, or manager, or director to another person or party who might have been previously terminated from the card networks because of things like high chargebacks or fraud, and then using these tactics to avoid risk monitoring. And then we won't spend much time on here, but there's also potential criminal penalties here. If you lie to a bank, it could be bank fraud, or sending false information over the internet. It could be wire fraud. So money laundering has criminal implications. So anyway, things to keep in mind. Obviously don't go down those roads. But that's one of the reasons why this industry is under such high scrutiny. And I think why we're now seeing more payment network requirements coming out of the card brands. So this is Visa, MasterCard, others that issue cards, maintain the card networks. And the first one we'll start with is stored credentials. So we're back to sort of applying to everybody again. But Andrew, you can.
Sure. Yeah. So I mean, the card network rules are just that. They're contractual rules. They're not laws the way something like ROSCA is. But they do govern the use of credit cards and obviously being able to access the payment processing system. And the card networks, Visa and MasterCard in particular, have established their own rules for what they call, stored credentials and recurring transactions. A stored credential would be where a merchant, for example, maintains the payment credentials so that they can make future kind of recurring payments, for example. Just like the federal laws, they're really focused on concepts like, disclosure, cancellation, providing refunds, those core issues that really go to making sure that the consumer knows what they're getting into and have agreed to do that. And they apply to the types of negative option programs we've been talking about today, recurring payments, installment payments, et cetera. So let's take a look at the Visa requirements, for example, just as one of the card brands. So when entering into the first sale, there's particular rules, and then there's also rules, for processing recurring sales. So starting with entering into the first sale, there needs to be disclosure clearly and conspicuously, and obtaining consent for the following terms, just providing a truncated version of the stored credential, for example, the last 4 digits of the account number, how the card holder will be notified of any changes to the agreement, how the stored credential will be used moving forward, and the expiration date of the agreement if applicable. And then in addition to that, if you're doing recurring sales, there needs to be express informed consent regarding the transaction amount, including all taxes and charges, or a description of how the transaction amount will be determined, the currency, the cancellation and refund policies, where the merchant is located, and the fixed dates or intervals on which the transactions will be processed.
Okay, and then a big point of discussion over the last several months has been new MasterCard standards governing negative option sales. These went into effect April 12. There are some new restrictions here, or requirements, I should say, and they apply to non-face-to-face transactions, so online and phone sales, for subscriptions to receive physical products. So these would be like vitamins and skincare creams, healthcare products, not Hulu and Netflix and downloadable types of streaming products or other types of things, but more the physical products. These products tend to have been at least subject to more FTC issues, maybe more prone to some of the issues that we covered earlier. So MasterCard is trying to deal with this in a certain way. So now these merchants who are engaged in this business must actually be registered with MasterCard. Billing descriptors, this is the information that appears on a credit card statement to the consumer, have to contain the URL where the consumer can go. And that's got to stay consistent. You can't have these URLs with a long string that are changing, or maybe different URLs with different product changes. So the point of that is really to give the consumer a place to go back to a website and ultimately cancel. Acquirers, which include the banks and processors that are supporting, transaction processing, have to take a much closer look at these merchants' compliance. So again, more scrutiny. So if you are selling a physical product on a subscription basis, you could be seeing more scrutiny. And then a prohibition, or not a prohibition, a requirement really to, on these banks and processors to monitor to make sure that multiple merchant identifications, which are merchant accounts, MIDs, they're not being opened up solely for the purpose of sort of balancing out lots of sales transactions among a lot of different accounts in order to evade detection. So that's a sort of a graphic of how MasterCard rules, what they look like. But they also cover trial offers. So once a trial period expires, the seller has to provide disclosures and obtain explicit consent before charging the consumer again. So this is really a new one and a tough one to deal with, because it's not a legal requirement under ROSCA. We did talk about the DC law, where if your renewal program, if your trial program is 30 days or more, and then it goes into a subscription, then going back and getting consent. But this is a MasterCard rule now for these trial periods, and saying that you've got to go back and get consent. You don't have to go back every time you're going to send product, but you do need to go back at the end of the trial period and obtain that explicit consent before sending more product and charging the card again. So also they want the free trial to start when the product is received, not when it ships, and they're very specific about sending a confirmation email once the free trial is canceled. Sending a receipt after every billing attempt, maybe that's the best practice anyway, but it's now a MasterCard rule. And then providing a clear and conspicuous way to cancel. Here, again, an online cancellation procedure. So I know we were actually out of time, and I don't think we have time for questions, but again, because we've gone right up to the hour, but please submit any questions you have. We'd always be happy to follow up with you and help you out if we can. So thanks, everybody, for joining today.